We're back. We're back and we're going to Florida. We're going to Florida. Let's hope their volume is better on Court TV than we just had to deal with on Law and Crime. But we did get to see Judge Beverly Canone, and that was refreshing because we haven't seen her in well, we actually did see her last week, so that's a lie. We saw her on the Turk case. I haven't been following this Sarah Boone case, to be honest with you, because I just didn't. I mean, it's so obvious that she's guilty, right? That was my initial opinion. So I just don't see. There's so much craziness. She's on like her 9th or 10th lawyer. So for those of you, you do have to hit like again. Thank you for asking. Who have been following it. You know, we have a very collaborative chat here. So tell us what you find interesting about it. She's a nut. She's, you know what? Whack job. Maybe whack job was invented for this woman. I don't know. Perhaps my opinion, my initial opinion, because I remember seeing the initial interrogation video and thinking, she obviously knew he was in the suitcase. She's taunting him while he's in the suitcase, begging to be let out. He's going, Sarah, Sarah, let me out. And she's like, you effing cheated on me. You effing cheated on me. I'm not letting you out. Hello, Julie Kaylee in Central Florida. Hello. Oh, thank you, Sarah in Schwackenhora. I cannot control that. Please post responsibly. Thank you. But we're here. I'm sitting in front of the computer. We might as well watch it together. Oh, yes. Oh, yes. We both reached for the gun. Donnie Not Wahlberg, no. And I have to go over that Condit case. Thank you for reminding me. All these things started popping up. We need to do that. If you know, you know. Don't tell. Top secret. We need to go over that complaint. I don't know that there's been an answer filed. Hit the like. Hello, Canada. Keith in Canada. From New England. Hi, Cammie. Go Big Red and go Chiefs. That man was just straightening out his hair. Okay, the judge is supposed to rule on the defense theory today. Thanks, Carly. Vinny does this one a lot. Yes. Oh, listen, speaking of Vinny, love Vinny. I've been following Vinny for, I guess, since he started on Court TV, like back in the early 90s or whenever that was. And I'm in a secret competition that he doesn't know about to beat him in subscriber count on YouTube. And I think we're only like, I mean, last I checked, we were like 5,000 subs apart. So if you guys could just like smash the sub button, that'd be so cool. Because that would really help me in my own personal quest to get more subscribers than Vinny Politan on YouTube. I think that would help me so very much because you guys are so cool that way. You're cool and you're kind and you're classy. Somebody was complaining today. Not really complaining. It was a very kind comment that she wrote on my last stream and said, she's like, Melanie, I love you, but there's so many commercials from YouTube. And so I want to tell you guys, I don't have any control over the amount of commercials that YouTube plays during my replays. I don't think you get commercials on my live streams, do you? I don't think so. So I have no control over how many commercials they show on my replay. And maybe because my stuff is getting more views, they're putting more commercials in there. I don't know. And everyone, right, get premium. See, I've had premium for so long, I've never seen commercials on YouTube. So I never had to deal with that. But for those of you who do have to watch commercials, okay, so live, you don't get ads. So that should encourage more people to check in on the lives, right? More commercials on the weekends. Thanks, DC. Sarah says, I get an ad on the way in if I'm late, but no interruptions during live streams. I mean, listen, the YouTube Premium, I don't know how much it is right now. $11.99. Like it's cheaper than, you know, Disney Plus or, you know, Netflix or Hulu, I think, because everyone just raised their prices. So if you love YouTube and you're watching YouTube all day long, in my opinion, it's worth it. Yeah, YouTube Premium is the best, right? When's the last time? I haven't seen a commercial in years. And even before I think I started doing my own streaming, I had YouTube Premium. So I don't know. Yay, Kirsten. Yay, Kirsten. Yeah, Christy's like, I watch enough YouTube to pay for premium. $13.99 a month it is, Kimberly. All right. Somebody said it's $20 a month. I don't think it's that much. 17, 13. Maybe it depends on where you live. Maybe it depends. Somebody said it's worth $19. I don't know. I think it depends on where you live. Oakley's like, I pay $26 for a 5-device family plan, but I don't. Or is that YouTube TV that you're paying for too, or just YouTube? I share it with my sister. No interference. Good to share the cost. Yeah. Look. Hey, look. They don't even pay me to say this to you. They don't. Kooky Carolinian. Can't live without YouTube, without premium. Zero patience, and I live here. So I'm sorry if you get a lot of commercials on the replays. You told Vinny, you told him that there's a competition. What did he say? Cheyenne, how the quack are you? How the quack are you? No ads, your channel. I don't know what that means, Miss Mojo. What's your channel? Oh, on my channel? No ads on during lives? Okay. Okay. It's like 4chan. Remember there was some app called 4chan? I don't even really know what that is, but Looney Booney. Oh, that's a good one. Adam drives Helen. Looney Booney. I like it. I'll allow it. I'll allow it. $18.99 for premium in Massachusetts. YouTube TV is $72.99 a month. It doesn't include YouTube. That's ridiculous, shouldn't it? Shouldn't include that. 1/4. I don't even know what that is. I don't even know what that is. So what is it that everyone is so? Why is everyone so interested in this Sarah Boone case? Because she's such a whack job. And I have questions too. And listen, I'm coming at you from not really have dug in. I haven't dug into any of these court documents. This is in Florida, right? Ashley Benefield tried to use the battered spouse theory. She was denied because they weren't living together, and there were some other issues there. They had been. But was Sarah Boone even married to this guy, or was it just her boyfriend? Were they living together? I have so many questions. I have so many questions. Delphi gets me upset too. I haven't even started on that. I covered it with Duty Ron, I think, a couple of times, like a long, long time ago, when they were trying to get Richard Allen moved from the prison to the jail, because he's not supposed to be held in a prison because he hasn't been convicted, but he's in solitary in a prison because the jail is like, we can't protect him, Richard Allen. I believe that Bob Motta from Defense Diaries is going to go to the trial. I don't know what just happened there. Bob Motta is going to go to the trial, and it's not going to be televised, the Delphi case. So that's going to be interesting. Law Junkie, I loved your special with Carly's attorney in that interview with the bio dad. Loathe him. There's another one. They've released the outtakes. And I said, after that, Court TV had 2 very fair pieces, one by Vinny and one by Julie Grant, on behalf of this motion for a new trial. So go Bridget. Hi, Janine. I'm sure the duo of RVC in the news last week. Would you ever consider doing a show about what happened there? Oh, you mean the Diocese of Rockville Center settling a lot of those cases? Yeah, I don't think the settlement has been approved yet. For those of you who don't know, what's the acronym for that? IYKYK is if you know, you know. If you don't know, you don't know. That I was lead attorney for the victims and survivors of clergy sex abuse here on Long Island in the cases that, when the scandal broke in 2002, the scandal broke in Boston, but I was lead attorney for the plaintiffs on Long Island in the Rockville Center against the Rockville Center Diocese for the victims and survivors of clergy abuse here. And after a very long 15-year fight, New York decided to change the law on the statute of limitations. I hate when people say statute of limitations, because the cases that I and some other attorneys had against the Rockville Center Diocese went all the way up to New York's highest court and were thrown out on statute of limitations because all of my clients had disclosed their abuse way too late after the statute had expired. So there was a 15 or 16 or 18-year fight, and finally New York decided to open a 1-year window for survivors to be able to sue on old cases of SA, CSA, and adult survivors to be able to, that's why you saw a lot of these cases in New York being filed against Diddy for old cases. Yeah, I would consider doing that. YouTube Premium is more if you get it through Apple than if you get it, like on your own. Thank you, people in court. Thanks, Cami Urchit. Thanks for your dedication and providing great content. I love your heart and sassiness. Oh, thank you so much. Thank you so much. Thank you, Mo, for your super sticker. Is this just going to be a big nothing? Like, what are we doing waiting here for this? Sweet Peach, I sent another YouTuber's chat to your page for the Carly Gregg case to watch your interviews with her. Oh, well, that's very nice, but I don't know if you should redirect people here too. But, you can, I don't like when people redirect my chat, unless, because I'm the only one who has it, I guess. I don't think Bridget is doing interviews. But she and I kind of bonded over that Carly Gregg case, and I was surprised when she responded to me. I just sort of reached out to her and said, do you want to talk about it? Because I was very interested in it. And then I you know what? I found another case today that I want to compare and contrast. And this is a case out of the UK. Well, while we're just waiting for the Sarah Boone thing to start, there's a 13-year-old girl who's on trial in the UK for stabbing a couple of teachers and then joking about being a celebrity. And the UK, their justice system is so different over there. They don't release the name of the 13-year-old. This happened just in April. They're not publicly identifying the girl. No, maybe they're back. It says here, police were called at around 11:20 a.m. that day on April 24th with three people, 2 teachers and a pupil being taken into the hospital with stab wounds. The girl, who has not been publicly identified, allegedly attacked 2 teachers as well as a student whose name has not been publicly released. Apparently, it's reported that the 13-year-old said, "I stabbed her. Oopsies." The deputy head of the school had apparently noticed the girl had sinister eyes, and was playing with something in her pocket. So, is it on trial right now? I don't think the UK allows cameras in their courtrooms either, right? So I'm going to look a little bit deeper into that and see if we can compare and contrast the way that our young teenagers are treated here in the US being tried as adults and the way that they're doing it in the UK. So if any of you know about that case, let me know. Justice is Truth 444. Thank you for the 10. Have you seen this new sheriff that killed the judge case out of Kentucky? So I was just talking about that on the stream that we just did on Brian Walsh. And I said, I want to go over the hearing with you and talk about it, get some court documents, and look at it together. Killed the judge right in his chambers on video. Somehow the teenage daughter's involved with the judge. That some people are saying that, and some people are saying that the story is that the sheriff was getting mad because the judge was helping his daughter and wife escape from him. I don't know. I haven't looked into it yet, so it's interesting. Thanks, Jazz. Yeah, you're going to see what you can find in the UK. If you need to look it up, the teacher's name is Fiona Elias, Elias. She was attacked by this student. That's one of the teachers. They are not releasing the minor's name publicly. Stephanie Sweedler says, no cameras, but if the case is very notorious, they will sometimes read the transcripts with actors at night. You're talking about Delphi? Here's the, here's the thing. To get the daily transcripts, if you can get them, Stephanie, I think Stephanie, you're an attorney too. You're an attorney. It is like thousands upon thousands of dollars for a daily. If the court reporter is even able to turn it around for you. I mean, it's crazy. That case is in Wales. Okay. Thanks, Welsh girl. Thanks for telling me. Yeah, so here, my friends, the Bank of America has just reported a widespread outage. It's completely down. Bank of America, this is just breaking news. Bank of America customers report having trouble accessing their bank accounts on Wednesday. That's a problem. If it's another hack. Yesterday, Verizon had a worldwide outage. Was it yesterday or the day that I covered the hurricane? That is why I have a sponsor named Aura that can help you free for 2 weeks to find out if your stuff is being hacked, if your social security number has been on the dark web, released on the dark web, because I use Aura and they told me that mine was found on the dark web. The link is below. Maybe one of the, oh, thank you. Scott's going to drop the link in the chat. You can go and you can do a free 2-week trial. Find out if your stuff has been leaked, because every day, it's also in the video description below. Every day, these new hacks are happening. And if you've ever had your credit ruined or your identity stolen, like it takes years to repair. Good luck. You know, it's hard. So I'm just putting that out there because that just broke. Stephanie, yes, I'm an attorney and I know that getting the daily transcripts is very expensive, but the tabloids absolutely did it for Harry's cases. Oh, okay. Okay. They've got a lot of money, right? I mean, I don't know that Bob Mata, who's going there every day, is going to pay for daily transcripts. Who are you saying does the dramatic readings? Because they should let me come in. I'll play a part. Some of you, so many of you, actually, I am an actor as well. Some of you know that because after handling all those church cases, you know, they kind of suck the life out of you. The litigation really sucks the life out of you. I just had I just got to take a break. Got to do something else. I want to do something different. Pivoted back to acting because I always wanted to be an actor as a kid. So anyway, I have an agent, multiple agents. There was a strike. Well, first there was a pandemic, which shut down the entire industry. Then there was a writer strike. Then there was an actor strike. And then I decided I'm just going to come on YouTube. So, so many of you said that they saw me on Evil Lives Here over the weekend. I guess they're replaying that show. I was on Evil Lives Here as like the wife of like a killer. Years ago, I did that show, and apparently they're still running it. So many of you sent it to me with screenshots like, is this you? I'm like, yeah, that is so old. It's on like Discovery ID, and they don't pay residuals, but I'm like, wow, it's like really, they're still playing that? I wish I got residuals on that. But they're not a union channel, so only union actors or union productions pay residuals. They did not. So for those of you who sent that to me, thank you for watching it. It was hilarious. It was so much fun. Oh, you think I remind you of Chelsea Handler? That's funny. I don't get that much ever. I don't ever get that. So thank you. Where can it be streamed? The Evil Lives Here? I don't even know. I think it just comes on Discovery ID every now and then. I don't even know. But it was fun. It was like I had so much fun shooting that. Oh, here she comes. She's coming in. Hey, Sarah Boone. There's no sound up yet, though. Make that bigger for you. Wackadoo. In my opinion. Looks like Sarah got a haircut, people are saying. 8,000? Oh, it's 8,000 now? I think it was down to 5,000. I know, Kelly. Kelly, I've auditioned for all the Law and Orders so many times. I really, really want to be on Organized Crime because I have a thing for Elliot Stabler. I mean, ever since, you know, that show's been on for 25 years. And they just moved Law and Order Organized Crime to Peacock. They've demoted Christopher Maloney, Elliot Stabler to Peacock, and I'm not happy about it. Although I have Peacock. But I agree with you. Oh, also, on the Law and Order original reboot, Tony Goldwyn is now the DA. He took over for Jack McCoy. Do you remember Tony Goldwyn from Scandal? He was the president on Scandal. Love him too. Stabler, yes. Oh, Stabler. Oh, Michelle Pfeiffer, I'll take it. I'll allow it. I'll allow it. Marzi, she's so unlikable like Shonda Vander Ark. Wait. This is funny. Indie girl, her hair's been cut by a knife and fork by the looks of it, or a hammer. Get your hair cut with a hammer? It's an old joke. I know. I do have to say, I do love Peacock, says Justice is Truth, 444. There's a lot of good shows on Peacock. And yet also, a lot of people don't have Peacock. I just feel like Elliot Stabler deserves network television. Even my mics are hot. Will she get the glam team she requested? Has that been decided? I don't know. I think that's what they're going to talk about today, right? IYKYK. I know. Tony Goldwyn from Ghost. That's right. Tony Goldwyn. Do you know that Tony Goldwyn, Gina? Oh, sound is coming. It's actually Goldwyn. He is like related to, I don't know if it's his dad or his grandfather. Remember MGM, Metro Goldwyn Mayer? That Goldwyn. He's the Nepo baby, but it's okay. I still like him. Thank you, Black Rose. The port workers went on strike. I saw that down the east coast of Houston. Oh, that's right. She did tweet that Rich Schiffer was like the Italian mafia. I like how I like how she distinguished between the Italian mafia, right, and the Irish mafia, like the Whitey Bulger incidents. You know, she didn't want to insult the Irish mafia. She had to make sure she put in there that it was the Italian mafia. I know, she's nuts, Kate. We were on a different stream and people are like, are you going to cover it? It's coming up. And I'm like, all right, why don't we just pivot over here and see what happens? Thank you, Sarah and Chalk and Aura. She got cut and is stuck in a suitcase, Jadzia. Zip, zip, zip. Maybe what do we need for this trial? A suitcase emoji? You know, we have a rubber duck emoji that I made for you guys from as such the last night's stream out of Norfolk County, Canton. So I'll show you the rubber duck emoji for members. Those are one of our little special perks that we have. Except I can't get into YouTube. YouTube is so glitchy lately on my phone only for some reason. Is anybody else having those types of issues with YouTube? Oy vey. Like I'm trying to click on it and it says we've got 2,000 views, like, but it won't let me click onto the live. Like, what? It says like it's already over. So, but it's not, because here I am with you and I think I'm still live, right? Joanne's like, is that a bicycle helmet on Sarah? Like, I can't get into it. It's not letting me in on my own damn channel. Okay. All right. There we go. It only shows me top messages, not all messages. I can't sort it on my phone. Thank you for those of you who are putting the rubber ducky in there. Rubber ducky, you're the one. Oh, Rachel, that's a good suitcase emoji. Looks like a briefcase. Somebody's saying I was people are panic buying groceries. Where are you, Max? Oh, because of the dock workers going on strike, the port workers. Sharon's like, I really like the judge on this case. He's not playing. Thanks, JB3. Sarah's trying to get her police interview kept out of evidence. Okay. That interrogation that I told you that I watched. Oh, no, she's got a new attorney now. I think this is like number 10 or number 9. We should watch her interrogation together. Yeah, let's do that one day. Oh my gosh, Tiff, Knox. I got sucked into every single YouTube version of Oh Yes from Chicago. If you know, you know. I won't sing it again because now it's stuck in your head. And I am so addicted to every single person who has done that dance. And I watch it on YouTube. I guess maybe it's on TikTok too. To the point where I reached out to the dancing weatherman. Do you guys know the dancing weatherman? His name's Nick Kosir, Kosir. And not only is he a weatherman on Fox in New York or like Fox streaming in New York, but he's like got millions of followers on YouTube and TikTok, and he does like all the dances, and he'll go to Times Square and he'll do the dances with like other influencers. I don't want to dance with him. No, that's not what I'm saying. But He did a really interesting show about his sobriety and that he's been sober for 7 years. And he's like, if any content creators want to reach out to me, I'd love to talk about it. And I thought that would be such an interesting show. Do you guys know the Dancing Weatherman? Yeah. Check him out on YouTube. Nick Kosir, Kosir. He's amazing. He's so good. And I can't play any of his stuff because the music will get me stricken. And then I have to go back and edit it. Like I had to go back and edit the Hurricane Helene stream that I did the other night for all of my Western North Carolina friends and people who have family and friends there, that how devastating that hurricane was. I played a clip from some organization that was feeding people for free because I wanted to get the word out, and YouTube like copyright struck me. So I had to go back and edit it out. First, I thought they just didn't want the word getting out about how bad it was in North Carolina, but there are some serious, challenges with censorship still on YouTube. Thanks, Em. Love him. Would love an interview. I thought it was so interesting. Did you see the one about his sobriety? That was really, really interesting. She's innocent, but definitely guilty, says AJW. Oh, he's working for free? He's pro bono? Says Cheryl Carson. Auntie Ree, we're waiting. We're waiting to see if her theory is going to be allowed, I think, by the judge. So their sound is not up yet. Cat Randall's like, that makes sense as to why it's every other short in my YouTube feed. I love it. I love it. Oh, yes. We both reach for the gun. For the gun. Congratulations, Em. Sober 11 years next month. Congratulations. One day at a time. That's amazing. Very, very proud of you, my dear. She still has this lawyer. How long has he been with her? For like a week? From the side, he kind of looks like Ted Danson. I mean, that's just my initial observation, but I have no idea what he looks like from the front. Ted Danson, who was on the last season of Curb Your Enthusiasm. Oh, now he doesn't. No. I take that back. I'm sorry. I withdraw. Withdrawn. Do they actually provide a law library in prison so the inmates can research law? It is my understanding that they do. Very many of them do much of their own research. Justice is truth. It depends on the jurisdiction. And many attorneys that are in prison wind up being jailhouse lawyers for other inmates, helping them file things. Pro se. Pro se means you are representing yourself as an attorney, and pro bono is when an attorney represents you for free, such as in the Carly Gregg case. Bridget Todd, who's been on my channel twice, we've had 2 shows together, who represented Carly Gregg, and Kevin Camp, her friend and co-counsel, decided that this was such an injustice that they decided they were going to represent Carly pro bono for free. And they did, because Carly's family and Carly did not qualify for a public defender in Mississippi. Oh, this guy responded to the wanted ad too. She put out a wanted ad for an attorney. Phil Donahue. That's it. He looks like Phil Donahue. A little bit from the side. Are we doing profiles now? All right, standing up. He's like, get up. Did you see him smack her? Like, get up. Judge is coming in. Get up. All right, can we turn the sound on, Court TV? She's in county jail, not prison. Okay, yeah. So in the jail, do they have a law library? I don't know. Maybe that's only in prison, Charlotte. You could be right. Miss Scarlett, how can you not qualify for if your family has too many assets? You will not qualify, not in Mississippi.
Thank you. Madam Clerk, I'm ready when you are.
Oh.
And just for the record, behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO. State, have you had the opportunity to review the second amended motion?
Yes, sir.
Are you ready to proceed on that today?
Yes, sir.
Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card? Or
Yeah, if you look.
Yeah, talking to the mic, please.
If you look in the very back,
Okay.
you see the Miranda card. The last page is the neck of the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can?
Yes.
All right, so ordinarily you need a custodian of records to authenticate the records, but the prosecution is agreeing to say they're authentic, so you can let that witness go. So they had the witness there just in case. Now they can release the witness.
I also have reviewed the 2-hour and 6-minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification as a DVD, courtesy copy,
Can't hear a damn thing.
body worn camera.
Like he's legit talking to the judge, not in front of a
I
mic.
have reviewed all of those in advance of today's hearing. Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1.
First time it's happening that we can't hear them. Rah, 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 rah. Yeah, like he's sidebarring by himself, but he's not because he's talking to the judge, but I'm assuming that defense counsel can hear him. Right, Julia. Maybe,
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Castle. Chelsey. Last name is Koepsell.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am homicide
How long have you been a homicide detective?
over 6 years.
And what's your total experience with the Orange County Sheriff's Office in terms of years?
I'm going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to
Trying to
notify
fix-
the
they're trying to
on-call
fix it.
homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes,
And each of the third weeks you will be on call?
yes,
And then
Can't even look.
through some other random distribution, it's determined who of the 4 will be the lead?
correct.
And it was your turn to investigate the death of Jorge Torres?
Yes,
And you were notified of this on February 24th of 2020 in the afternoon?
yes.
About what time were you notified?
I mean, also understand that her mic, her mic is not the same mic as, that's for the courtroom. I don't think that's the mic for the court feed for court TV. So like, I don't know why they can't figure this out. It's 2024. This case happened almost over 4 years ago.
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Owen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
It's so funny when like another creator comes into your chat and they're like, oh, this is live now. And then they go and then they start broadcasting it at the same, like, it's too funny. IYKYK.
With the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence
Yes,
and later executed?
correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's up here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you call what you
Hold on. Let's see if it's better on Law and Crime.
I believe we then sat Sarah into the
not.
unmarked vehicle and had a conversation with her.
was that conversation in the unmarked vehicle recorded?
It's not better.
Audio recorded.
And can you describe this asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay.
The same.
And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in a unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct. I did.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for a 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, of course not.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. And, so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house, but actually able to leave.
Prior to that, had she been detained and requested not to leave the scene?
One more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was.
Don't
So
do
I
it,
just thought it was a more
Grace,
controlled setting. at the
Don't do
sheriff's
it.
office.
All right. And when Ms. Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to the window and request that she was there to meet with me. They would call me. I would tell them, yes, sign her in. And then if I'm not mistaken, I believe Detective Lowen went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
In your testimony is it wasn't you?
And I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have any other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about?
Okay, I'm going to break for a second just to tell you that the microphone that is in front of this detective is not the microphone for the television feed. That is the microphone for the courtroom. It is a different mic that is used for the pool photographer or the pool camera. So, you know, it's not a matter of her pulling that microphone closer. It's a matter of Court TV or Law and Crime or whoever the pool photographer is to get a mic closer to the witness. It's just, I know it's hard. That's why I have the closed captions on, but we're doing the best we can, my friends. That's all we can do. I'm going to go off stream for a second because I have to run downstairs and do something. Don't worry about me. I'm going to be right back. This is going to be playing while I go. Do your best. I know you guys can do it.
About what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator?
Yes.
And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That's correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what, one more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car? Or
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're gonna go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Owens. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because it's the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights to
But
remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida or the United States and federal case law and the state case law interpreting the United States Constitution. The policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
Yes.
Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is.
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card, but continue.
I'm sorry?
It's not on my Miranda card that I read from, but you can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is in reference to the policy, yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Ooh,
Sustained.
did you fail to get the most
Somebody-
updated card?
somebody dropped the ball somewhere. Did not like that. Thank you, Fun Size, for recapping what everyone cannot hear.
Or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that
Okay.
there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back?
No,
You did not tell her that?
no, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she would be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
That was a Jen McCabe. She was like, do you have documentation of the phone call? Can I see the receipt on that before I answer? She doesn't remember.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come?
Hi, Julia 543. I do know what I missed because I was actually listening because I had to run in my car to go to the bus stop. But if you want to type out the summary, please do. I would appreciate that because I can't do both at the same time. Commentate to you and type it out. So thank you, Julia.
Come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines. Yeah.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together or were you making all the calls or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know. Off the top of my
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner or were there anybody else there?
I don't recall if Detective Loan was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the two videos from her phone the day before the autopsy?
Objection, relevance. The custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing an intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway, that they had already made a decision that she was the prime suspect, they had probable
What does that
cause.
have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first.
Okay.
The objection is sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah.
Okay. We love strong women here. We are strong, direct women here, which is why we do not diss the witnesses other than their demeanor, their testimony. We don't talk about their looks in a negative way. We don't speculate on sexual orientation or body shame or anything like that. So let's just guide our actions accordingly in the chat. This witness reminds me of, I'm going to date myself now, but the original Charlie's Angels, Jacqueline Smith, same haircut. I love it.
Boone arrived that afternoon for the interrogation. She was not free to leave.
She was not going to be free to leave.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway.
Correct.
And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the two videotapes that you saw from Sarah's phone.
objection relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to Jorge Torres from the autopsy?
Objection relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the two videotapes that you had found on the phone.
Objection relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the two videos and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection irrelevant.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I've not looked at your motion.
Okay.
Why would the witness ever see the defense attorney's motion? It's something that she would never, in my opinion, see. So that was a kind of a weird question. Yeah, let's do that. How about we reserve judgment and listen to the witness? The only thing I want to say about her right now is that she's gorgeous. She also knows that this is going to be televised. She could be nervous. Let's just take a step back and listen. Because if it is true that the judge decides as a matter of law that Sarah Boone was not properly Mirandized, then anything that resulted from that improper Miranda, or Mirandizement, let's call it, could be excluded. And that's what the defense is trying to do. We're suppressed. We're not allowed into evidence. Fruits of the poisonous tree.
Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Yeah.
Okay.
Best evidence is the recording, and that's right. They have a recording of this, so these questions could be considered improper because the judge can just look at the video and make his own determination. It doesn't matter what this witness says, really.
Motion sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Again,
Do you recall making some comments to
Best
her
evidence.
prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
hold on. I just want to take that back because that was overruled for a change. So hold on. Do you remember reading her rights? Let me hear what the question was again.
Do you recall making some comments to her prior to reading her the rights?
Making some comments to her prior to reading her the rights.
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time.
I assume that's not the first time you've read Miranda to a suspect.
Objection. Improper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Improper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
Can you tell us if you recall?
1985. We have 1,985 people watching right now. 1985 was a really good year. That's what it just reminded me of. But if you would all just, hit the like button, it would really help the algo, as they say in the YouTube world. Thank you so very much for playing.
Saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask for question number 10.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
MBM Esquire, some of us just have a Bianchi face. I don't know what to tell you. It's so true. Oh, look at this. We get to zoom FF a little bit. We are a little tiny bit behind.
Yes.
Is that filled out of waivers and affidavits?
It's filled out by me.
Hold on.
Yes, this is our,
If you would, see if you recognize that document.
yes, this is our waivers and affidavits.
Okay, he said, do you recognize this document? She said, yes, that's our waivers and affidavits filled out.
Is that filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
And was that form filled out as it relates to Sarah?
We're talking about just this top, right?
Yes.
Okay, I'm sorry.
He may be grasping, but remember, he doesn't have a lot to work with. It's going to depend on the judge's interpretation of the law in Florida.
Does it what?
Does that form, is it filled out as it relates to Sarah Lynn?
In the case, yes.
Is that her signature or not?
Yes.
Did you see her sign it?
Yes.
Is that your signature? Did you see her sign it? Yes, yes.
Your signature below?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no.
Okay. You would agree that there's 9 questions on the form?
Yes.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the 5th Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed the Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell? and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
Okay, to catch you up. This attorney is arguing on behalf of Sarah Boone that because this detective did not say to her, do you understand these rights as I have read them to you? That's the one that she left out. The judge is saying all of the case law, in all of the case law that we have here in the state of Florida, that is not one of the required rights. Maybe it's on their card. Maybe they should say it, but it's not a requirement under the law of Miranda. And I don't think he's going to win this argument. Now, you have to be Mirandized whenever you are in custody. And whether you're in custody depends on whether you feel, not really feel, whether you have the right to leave. If you have the right to leave, you're not in custody. And you see it on TV all the time and in many other cases that we watch. I want a lawyer. I'm leaving. I'm not going to talk to you. I'm leaving. If you have the ability to leave, you are not in custody. They're not denying that she was in custody, but they're saying it doesn't matter that we didn't say to her, do you understand these rights as I've read them to you?
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read?
Oh, so I was right.
And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now.
Okay, so she did say, do you understand? Mama Jama is explaining. She didn't say, understanding these rights, do you waive these rights? Okay. A little more technical. Can he distinguish this in the case law? Will the judge buy it?
So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement,
Could be
and whether that
distinguishable.
waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the sheriff's department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that
Oh, yeah?
question
Like today?
and how it ties into the case.
Oh, yeah? Like, is she going to testify today?
I understand that all they have to read is those four, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue.
And sometimes you need to make new case law, right? Like in the Karen Reed case where they want to call the jurors back because the jurors are saying we agreed to acquit her on 2 of the charges. There is no case law that exists because it's a case of first impression. It's never happened before. Interesting.
Of the decisions in Thomas 351, Southern 3rd 197, and Owens 41, Southern 3rd 352. There's it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, detective, that after you read her those Miranda rights,
What happened? Uh-oh, something happened on their stream. What had happened? Long crime.
More evidence.
That was weird. That was
that was
them, not
without the
us.
autopsy? That was without the 2 videos from her phone in the squad car?
Yeah, I didn't, at the time of the interview. Yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
Ruh-roh. Sarah came with a list of questions she was going to talk no matter what. Debbie Jo was like, apparently the stream has decided it also has the right to remain silent.
That's all the questions I have at this time.
Thank you. Any redirect?
Nothing.
All right, can this witness be released?
I'd like her to stay.
All right, subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction of the card.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce. more witnesses.
Dude, I can't even hear you in my earbud to repeat what you're saying. A for effort for Owens, Mama Jama. She's a bad mamma jamma. Just as fine as she can be. Oh, we get to FF for those of you in the Gen X generation. Remember the desktop tape recorders that we had with REW and FF?
Any,
Same objection. It's irrelevant.
is it the, any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the? Okay. Can I see it for a moment, please? Thank you.
Sweet Magnolia Bell says, seems this defense counsel is already getting a
Any
lot
additional
further.
argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you, any additional argument?
Same arguments I've made.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
Sweet Magnolia Bell says, seems this defense counsel is already getting a lot further than any of Sarah Boone's previous attorneys.
And
Just saying.
Mr. Owens,
Ooh, he
you
just
have
put
one
his arm
additional
around
exhibit
her.
as well?
He just put his arm around her and patted her, and that made me wicked uncomfortable. Hold on. Look. Oh, I don't like that. I mean, look, I'm sure it's just
And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge, it's the policy of the Sheriff's Department.
Do you know what page specifically those policies are on?
I mean, even when the sound does come up, it's totally
Page
garbled.
14 of 22. I'm going to give you 2 more pages.
Oh, we got some
Is it
young millennials.
beginning of paragraph 4, waiver of constitutional rights?
Yes.
Thanks, Cherie. 10/10/77 is when she was born. So she'll be having a birthday next week.
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's 2 different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P.
Mhm.
And then it goes on to the next
Not a thing.
page.
It's just I don't know.
14 of 28. Specifically 2A on 14.
Thank you, KPT, for doing the math. She will be turning 44 next week. Sarah Boone. Nobody said he was sleeping with her. I wouldn't touch my clients like that. That's all I'm saying. I'm not a touchy person like that. I mean, you can lean in and talk to somebody in a way that doesn't involve touching them. A lot of people don't like to be touched. I'm just pointing it out is all.
Anything else?
No other argument, Judge,
Okay.
other than what we talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence over objection as states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Oh my gosh.
Ms. Boone can approach the podium.
She's getting on the stand, you guys. This is a bonus.
She was previously sworn at the beginning.
Bonus. Didn't know. Didn't know if you're ahead. Please no spoilers.
Judge, I'll be here.
She's been dying to talk for a long
Yes,
time.
sir. Hey, and the deputy's got to move her.
Catherine's like, did she get a cake in jail? A cake with a file? Stop. Grace Space, our youngster in the chat at 25 years old. Thank you for help changing our demographic in the audience. I love that for you.
Ma'am, you've already
For
been
your
sworn.
friends.
Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Speak up.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding Jorge Torres in the suitcase.
Stupid.
You called 911.
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
Mental state, not middle
Very
state.
confused. Was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Ah,
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together
the interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained and stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the 2 detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Hopesall was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that
Right of his
evening,
family?
You were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had
Great question, Scarlett Sullivan. Can this prosecutor use this testimony in the actual trial? Yes, this is testimony under oath. This can be used in the trial against her.
consented to that. You signed a form allowing them to take the phone.
Yes.
Have there been any discussion about returning the phone?
Kopsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Kopsel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
She was trying to trick me.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled.
Okay, whose face?
You may
is in
answer the
front of
question,
camera?
ma'am.
By the way, sir, move your head away from the front of the camera. Like, who does that?
I know she said yes, and now I don't know what's pending and how to object to it.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Oh, so she's saying she
Was there any
she tricked her into coming down to the sheriff's department because she tried to get me to sympathize with her pregnancy. Because don't you remember when you were pregnant? It'd be so much easier if you came down here.
discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator? Where did you go from there?
He brought me into a very small room and they had me sit down. And then from there, I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video,
Yes.
correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we
Swipe or keep swiping. It's not a stream unless I swipe. I haven't swiped myself out in a long time in my defense, but don't worry, because the second I did do that, I stopped the hearing, so we didn't miss a damn thing. We didn't miss a thing. Yay, I'm back. The Melanie, I know it's been a long time since I swiped. Sorry, guys.
how did that make you feel?
Sustained.
Let's get back a question. Now we're going to get into her feelings. I'm here for it.
Prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
We just have to do
Yes.
it.
How did that make you feel?
Sustained.
Yeah, we don't care about her feelings.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
In
Were you
every
polite with
way.
them?
She's so damn cooperative. Look at her. What a good girl. Pilgrim Shadow gifted 10 memberships. Thank you so very much. Pilgrim Shadow is a fellow deadhead and always comes in here with a Grateful Dead quote of the day. Thank you so very much. And to everyone who got them, welcome. This is really exciting. We didn't know we were going to get to hear Sarah Boone testify today. But here she is trying to tell us what a good girl she was. How she tried to cooperate with them in every way during the interrogation.
Very.
And when she said that, we just have to do it,
We just have to do it.
you said, just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
What do you mean?
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
Oh, she's the smartest person in the room. She wants everyone to believe she's the smartest person in the room. Normal protocol. Thanks, Cat Artist, for the 5. I appreciate you.
So she read the Miranda rights to you.
Except number 9.
Except number
Number
9. She
nine.
read the rights and then she said,
She became a jailhouse lawyer, by the way, when she was in jail. Remember for how long she represented herself? I think, is this her 9th or 10th lawyer? Refresh my recollection. Except number 9. For how long do you think she's been practicing that line? Except number 9.
do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
She knows her case better than anybody, you guys. She knows her case better than anybody. She was even able to get this guy to represent her for free because of her creative ad that she posted. Oh, my freeze game is on point today. That's right, Michael. You know me. You get me, Michael.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant. She's in custody.
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space.
Right, but she was in
she was
custody.
That all goes to
She was
whether or
being
not,
questioned.
But she was in custody. The state has said they've agreed that she was in custody.
Let me think. She was being
This is called When You Smile for the Camera. You know I love you better. He's performing. Now he's performing for the cameras. Who knows that song? Name that tune. And the artist. I didn't sing it very well, but I never do. And you know that.
questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
what does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
Subjectivity matter.
excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Jim corrected himself. Yes, CW, that is Peg by Steely Dan. Thank you. I often think in song lyrics. So many of you do, and so many of you know. Doesn't matter whether she thought she was in custody or not. The state is saying she was in custody. They're agreeing to it. So you're arguing a non-point right now.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Her feelings don't matter.
Ma'am, that day, You came to the sheriff's department to get your phone?
That's, yes,
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Oh, yes. Oh, yes. Oh, yes. Oh, yes.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then?
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Please don't pretend you don't understand the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what.
Don't testify for her, defense attorney.
Had alcohol. Under
It's
the
okay
influence
because
or
there's no jury there. So his performance today is really for the television viewers like you and me. Sarah Boone's Farm, Thomas T for the win. Somebody should create that Strawberry Hill. Boone's Farm, Strawberry Hill. Remember that? Do they still make Boone's Farm? Let's take that back a second.
Influence of alcohol that afternoon, correct? Okay.
Judge, I don't think she understands.
Judge, I don't think she understands.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what. She said that she had alcohol under the influence or impaired.
The objection is, the court does not.
Maybe he's a Dewey lawyer. She said she had alcohol, Judge, under the influence or impaired. As if was it 0.08 or greater or less?
Entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay.
Oh, please, you looked it up. Of course you looked it up.
And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements through State's Exhibit 1, correct?
Regarding the,
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all of the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
Sharon says she's getting mad. She'll fire Mr. Owens by
Mr. Owens, it's your motion, sir. You may proceed.
I'm sorry. I'm sorry. The audio is so garbled, you guys. It's not me. It's the pool camera, but we're still here for it. And here is the argument. FF a little bit. We should be able to hear this better, but it's still a little bit garbled. He's prepared.
It's my understanding of the law regarding Miranda. First issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, Go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him.
That is the purpose, yeah.
The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. coupled with the fact she doesn't have the 9th question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then
I do appreciate the way the judge is just allowing him to go on and on without interrupting him, without asking any questions. He's just letting him say his piece because he knows if he doesn't, he's going to get another letter from Sarah.
Detective Copsell goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Copsell had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Copsell's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Copsell's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Copsell has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, and for the record, there's 2 exhibits that I tried to introduce. They will be admitted
Correct.
into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Just a clarification, but she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying.
Bring her in then outside the presence of the jury with the leg shackles. And she's sitting there. They don't necessarily, it's not prejudicial. She's going to be hands-free. She likes to take notes. Hopefully she won't strangle him.
On the case in this
Yes, sir.
courtroom, there's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to
first.
see her walk in and out.
So
Right.
the only time is when she testifies. So
Oh,
I guess that only, I don't know.
The only time is when she's planning on testifying at the trial. Well, there you go. You heard it here first. I don't know if she's already announced that, but he just said it. Her fleeing would make a great Lifetime movie, says Wine Yogi.
If you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny as she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to
fine.
have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints.
There's going to be a privacy panel. They're not going to be able to see it. I mean, you could argue till the cows come home in Boone's Farm, Strawberry Hill. Sarah Boone's Farm, Strawberry Hill. You could argue till those cows come home. She's going to be in some leg restraints, I think. But now that we find out that this is going to happen next week, I think I do need to cover it. You guys let me know if you want me to cover it and do live streaming of the trial, but I don't know that there's anything else happening. So, hey, I'm here for it if you want it.
Restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. There are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have
She
every
understands
intent.
that, but she didn't understand her rights. Is that what you're trying to say? I mean, come on, shield and sword, my friends, shield and sword.
That she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported with her in the morning each day of trial. with regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you cited to, spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here.
Makeup equals contraband, my friends. You heard it here. Makeup equals contraband. They don't even sell it at the commissary. Makeup.
I say the paralegals. One's a lawyer now, and the other is a consultant, but they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but.
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting at 9:00 every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45. And I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any.
Why do you need to take measurements for clothing? She can tell them what size clothing she wears. Measurements have nothing to do with what size clothing you wear, Judge, just so you know.
The secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed.
Judge, and then I think there's something about hair as well.
I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry. Yeah.
Tee it up, a golf analogy.
Yes.
She wants to wear makeup, yes, on street clothes in court, and they're going to allow it. I'll allow it, he said, not in so many words, but he said, okay, your staff can do a makeup.
Corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person.
That is going to be, you know what? Because apparently maybe P. Diddy in the baby oil that was found, there might have been drugs. There might have been a drug in those bottles, not real baby oil. So maybe the contraband makeup that her attorney's staff is now going to have to apply in the courtroom before 9:00. The sheriff's office is now saying that we don't know what you're going to be putting on her person. Maybe it's going to be laced with drugs.
Some facial makeup.
I understand, but
I don't see.
DOC and sheriff's officer tell me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay.
There are ways in jail to do makeup.
Okay.
Like somebody said, Lori Daybell used candy as blush. But I agree with Olivia. They should be, if she was out on bond, she could do her hair and makeup, but I don't know, they have a concern about what would be put on her as makeup. There are other ways to do it. They use toilet paper rolls to curl hair. Her hair's too short now to curl it, but
An order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
Yeah, why can't they bring some makeup wipes and remove the makeup?
The
Law junkie
enlisting-
says it has to be removed before she's transported back. It's contraband, so can't they remove it? Like, just bring some makeup wipes and remove it before she goes back on the bus or back in the back of the car. I don't know.
I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense. And we have listed and plan to introduce the fact that Jorge Torres had been arrested, I think 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme.
All right, so they're using battered spouse. Have they been allowed to use battered spouse, or now we're going to decide, he's going to decide whether they can use battered spouse? And now he's performing for the cameras because he was arrested, apparently. Jorge, he's calling him George. Is it George or Jorge? Torres was arrested 3 to 4 times prior to the event where he died in the suitcase. And she had asked to drop the charges 3 out of 4 3 of the times. This is all going to go to battered spouse. Well, he's given us a little bit more into the defense here.
So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot.
There's a video on her phone about her coaching. Hold on a second. Is this new information? You guys who have been following this all along, tell me. Listen.
Immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone.
Okay. There's a video of her coaching the victim on how to drop charges against her on her phone. Did this woman like record everything? Stupidly, the way she recorded George in the suitcase pleading, Sarah, please let me out. Sarah, please let me out. Interesting. Yeah. There's a video on her phone, we're finding out now, of her coaching George how to drop the charges against her prior to his death, obviously. So she was abusive too. And there was also, he had filed charges against her. That's interesting. It's good that we get to like be a fly on the wall at these hearings. So she's right. She recorded everything. She's not a smart aide. And he's in the suitcase saying, I can't breathe. Please let me out. Rule number 1, don't write down or record your crimes. Well, okay. Is this new? Tell me.
So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against Jorge Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brandon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, y'all's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brandon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. Go ahead. I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cause challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
All right. So what? You're going to see you tomorrow morning at 9. Wait, hold on. What did he say? Monday at 9 a.m. for jury selection. Monday, 9 a.m. Sarah Boone got on the stand today to talk about her position on things such as what she understood and did not understand with regard to knowing her rights and how they tricked her to come into the police station because she thought she was going to be getting her phone back. That's her story, and she's sticking to it. We've also learned that she's going to be testifying at the trial. So that's what we have learned. Tomorrow is Rosh Hashanah. Happy New Year and Lashana Tova to all my friends who celebrate. That is why there is a court holiday tomorrow. It's Rosh Hashanah. Many of the public schools are also closed. So he says, judge says, I'm working tomorrow, though, even though it's court holiday, I will be working. I will have an order to you by the end of business tomorrow, close of business, with regard to such things as the makeup, the leg shackles. They're going to be doing some depositions tomorrow of the experts on battered spouse syndrome. And the prosecutor said, based on how those depositions go, I anticipate that I'm going to be filing a motion to exclude any defense of battered spouse syndrome. So we will see on that. Let's go to the chat for some questions. Thank you, Cami Burchett, for thanking me for my dedication and providing great content. This was totally unexpected today. I love your heart and sassiness. Oh, thank you so very much. 20th Century Fox, I think we should figure out why he went in the suitcase. I don't buy the hide and seek. Checking the size for smuggling. Trojan horse, what is it? That's a great question. Thanks for the 5. Rebecca Jones, we don't release names for young offenders in Canada. That's great. Thank you for letting me know that. We were talking about a case that's being tried, I think, in Wales right now. 13-year-old. It's the Youth Criminal Justice Act in Canada. Thanks, Rebecca Jones, for that. Marta says, please don't forget Carly, her funds stalled. Help if you can. The link to the Carly Gregg Defense Fund for the appeal is in my prior video on Carly Gregg videos. Thank you so very much. Mama She says, wine bottles and suitcase emojis needed for this one. Thanks for your 10 years. Such a fierce supporter of the channel, Mama She. Kimmy says, I remind her of Lindsay Wagner. I'll take it. I'll allow it. Thanks, Kimmy, for the deuce. Who also said this about slapping lipstick on a pig? Thanks, Kimmy, for coming in twice. Tracy, for your super sticker. Mama She on another channel. We call her Boone's Farm Barbie. Brooklyn Janet says, thanks. This is better than any TV drama. Thank you, Brooklyn Janet. Nina, am I the only one who feels for Sarah a bit if she was abused and just had enough? Well, she's going to get up and tell her story. So let's listen to her story. I'm willing to listen to her story. I want to hear it. Nina says, I give her a chance. He was abusive. We'll see. I mean, let's give her a chance. Let's decide we're going to give her a chance. She's going to get up and testify. They've already said that. We don't know if she's going to. Some of you wanted to see the ad that she posted for her attorney, so I pulled that up for you. And apparently, is that how she found this particular attorney? Let's see. Here's the ad. And there it is. Inmate seeks attorney. Let's see if we can make this. Looking for a prosperous challenge? Ready for your close-up? Not on television, although it is on national television, it says. Hold on, I'll just zoom in so we can read it together. Looking for a prosperous challenge. She has very nice handwriting. Ready for your close-up? On national television, are you zealous with a side of keen? Show the world who you are. With your original creativity, extraordinary expertise, confident ingenuity, qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration. This reads like a LinkedIn profile or a want ad. Extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client, and care with the ability to think differently and overcome all circumstances. Epic opportunity awaits. Sarah Boone, there's her inmate number, Orange County Correction Department. Invest in the oppressed, believe, XOXO. And that's how we found her, through her ad. Wine Yogi says, I work in marketing communications. Maybe I should hire her. Maybe you should. Maybe you should. Oh, thank you. Blessed Mom from Texas says, this is my longest membership on YouTube. Much love. Thank you. Much love to you too. And that is where we are today, my friends. This was fun. We did a hearing on Brian Walsh this morning in front of Judge Beverly Canone, and then we just streamlined into this one. So thanks, you guys, for hanging out with me all day, pretty much today. It's been like 3 or 4 hours we've been together today. So thank you so very much to the moderators who worked tirelessly to make this a really fun and safe place to be. Thank you for being here today. Smash the like button on the way out, if you wouldn't mind. It would really, really help the channel and the algorithm. And, hit the subscribe button too, because it's free. So thank you, everyone. Karen Durst, just finished my first jury case. Go figure. It was an aggravated murder case. It was awesome. You mean you finished your first jury case as being on the jury, or jury trial as an attorney? If you sat on a jury, that's awesome. I'm so happy for you. Everyone should try and serve on a jury. I don't know why everyone tries to get out of jury duty, because it's really an amazing experience. I wouldn't know, because I never get picked, because I'm a lawyer. They don't want me. And because usually when I go in for jury duty, I know the attorneys and they're like, yeah, bye, Melanie, go home. But I wish I could, because it would be quite an interesting experience. So this was fun. We're going to be covering this. I guess we'll be live streaming the trial now, because all of you want to. So that'll be fun. We'll make a open suitcase emoji. We'll do it. Christy, I'm here for you. I'll do that for you. And, who knows what else could pop open tonight. So you might want to hit the like button and the subscribe button and get all of the notifications. Because like today, I just went on and said, if anybody wants to come, they'll come. You guys came. You came. If you build it, they will come. Thank you so very much for your classiness, for your dedication, and for being so awesome. Yeah, there is an unedited. They released the outtakes on Kevin Gregg and Carly Gregg, and so I may come back later and do that for you with the Court TV stuff if you guys want to watch that. Luggage tag emojis? Maybe. Somebody said Peter Tragos is matching donations for the North Carolina hurricane victims. I haven't seen that. I will look into that. I didn't know he was covering it. And I do watch his stuff when I can. Unless we're covering the same stuff, then I don't watch his stuff because I want to have my own opinion and not be swayed by other law tubers' opinions. So we'll do that. Thank you. Oh no, thank you, Wine Yogi. Boone's Farm. That's what we're calling this child, Boone's Farm. Okay. I got that first. Nobody else is using Boone's Farm, right? Is Peter on right now? Is he on right now? Wait, hang on. I will. You know what? I'll send you guys somewhere. Let's just hang on. Hold the phone because I don't even think he knows who I am. But you know what? If we can cupcake invade Peter Tragos, let's do it. He doesn't really, I don't know that he collaborates with other creators much, but that would be kind of cool if we could get like a panel together like they used to do, right? In the beginning of LawTube, when they used to like do like when they did the Johnny Depp trial in Rittenhouse and they had like 100 lawyers. It wasn't really 100, but on the panel. Wouldn't that be like kind of fun? All right, hang on. Let me just redirect you somewhere. Let's see where we want to go. Where do you want to go? Do. I don't think he's live right now. I don't see that he's live. He mentioned me before? What? You're joking. You're joking, Law Junkie. That's not true. But if it is true, that would be fun. Cameron misses the panels. He's not live right now. Let's show him who you are. Melanie, he will totally collab. That would be so fun. He's the Sarah Boone expert. Well, 11 because StreamYard limits you. Yeah. Oh, he's not on right now. Mazza is live. What's Mazza doing right now? Hold on. I don't see him. I mean, oh, you know what? I don't know when Brian is coming on. He's coming on at 5. It says 5. Oh, that's tomorrow? Oh, forget it. No, forget that. I don't think we're going to hear anything on jury selection. I do not think. Here, you mentioned me a lot during Karen Reed. I'm shocked. I'm shocked and I'm not hard. I think that's awesome. He does? I had no idea. Defense Diaries, but they're covering this, so they're going to be done. Peter is how you found my channel? What? Wow. Wow. Yeah, everyone is covering this, and I don't really see much. Duty Ron is upcoming. At what time? 8:30 p.m. He's going to do why Jennifer Soto is not being held accountable. But I don't see anybody who's on now that you oh well, we can't really do an invasion right now. Sorry guys. You want to go to Broken Baker? He's covering something called Ohio v. Quinton Nixon. That's so interesting. I mean, that is so interesting. Wow. Wow. All right, I'm going to send you to Baker because he's nice to me. So go on over there and watch it if you like. Tell him that you're coming in for a cupcake invasion. So if creators are nice to me, I like to do it. Okay. All righty. I don't see that Mazza is live. So go on over there. Cupcake invasion to Baker. Be cool, be kind, be classy. Love you guys. See you soon. Bye. Thank the mods. Love you, mods.